Good morning, everyone. I'd like to ask everyone to please silence or turn off your cell phones. I also wanted to announce that Rami Aziz, who was supposed to be on our panel yesterday, was not able to attend for health reasons. I should have announced that yesterday. He did very much want to be here. Okay. I'd like to call up again Nitsana Darshan Leitner to open today's conference.
Good morning, everyone. I believe we had an amazing day yesterday. And we are planning even better one today. We have great speakers about to join us in different panels, and which in the end we really hope to achieve our goal and to start and advance a discussion about changing the law of war. One of the threats that Israel is facing today, and we saw it since the beginning of this current wave of terrorism, is the incitement from Palestinian groups, from terror organizations, or from extreme Palestinian figures that call other people, other fellows, to go and kill Israelis. But this incitement that was going on in the previous wave of terrorism, in the first Intifada and the second one, which used to take place in the town squares, in the mosques, on leaflets that were printed out and given to the mass, is taking place today in the social media. You will find thousands of posts calling to kill Israelis, calling to stab Jews. You will find pages called Stab the Jews. You will find videos illustrating how to stab, where exactly to push the knife, how to twist it, what type of poison you should put on the knife before you go and stab. And then, when these terrorists go and stab, you check their Facebook page and you will find posts that they just put while before, declaring that they are going to become Shaheed. They are going to liberate Al-Aqsa Mosque. It's time, they claim, to open a new intifada. And after they go and stab, you'll find thousands of posts endorsing their act, glorifying it, encouraging others to follow them. And indeed, all these terrorists are 15, 16, 17 years old, teenagers, have Facebook page. The Israeli government turned to Facebook, which is the most popular social media network among the Palestinians, and asked them to turn the incitement down. But Facebook said that they are not getting involved in this conflict, not getting involved in the content on their pages. They are only a simple bulletin board. It's not their job to monitor any of the content that goes on their pages. So we decided to take Facebook to court. We called Israelis to join the lawsuit. Within 3 days, we got 20,000 Israelis joining the lawsuit. We filed an injunction against Facebook in New York. We asked that Facebook will turn down the incitement, will shut down pages, will delete posts that call to stab Israelis. And we also ask Facebook to be proactive, actually to monitor the incitement and to take it down themselves without being alerted or called to do so. We claimed that Facebook has the tools to do so. They have algorithms that can assist them to monitor, to track these words and take them down. The same way Facebook knows what type of coffee I drink in the morning or what I like to do in the afternoon, they can monitor these words. Facebook filed a response. They say that they are immune by the Communication Decency Act. This is a law from 1996 that Congress legislated in order to leave the internet open. That grants blanket immunity to servers, including social media networks, for the content that goes on in their pages. We filed our response and we claimed, first of all, when Congress legislated this law, they didn't envision this type of incitement that really caused people to go and murder. This type of speech that causes an imminent and clear danger is not protected by the First Amendment. This should not be included in the Communication Decency Act. We also claim that Facebook is proactive, that they are involved with their users. They push ads. They make a lot of money getting people on their sites. They actually connect between those who call to kill Jews to those who want to do it. And lastly, we claim that Facebook gets involved where they want to, depends to which side. And in order to prove that, we opened two pages, two identical pages. One page calls to kill Israelis, one page that called to kill Palestinians. And then we posted identical posts. And we put identical images, just as one difference. One against Israelis, the other one against Palestinians. And after 2 days, we asked Facebook to take both pages down. Facebook immediately took the page that called to kill Palestinians down. They sent us a firm message saying that they checked the page and it does not fit their community standards, whereas they left the Israeli page up. They sent us a message saying that they checked the page and it does not violate their community standards. Let's watch and see. incitement on the social media, in the PATV, and other places that call to kill Israelis have to be dealt with. This is one of our discussions today. We had several issues discussed yesterday. We have more to be dealt with today. Our purpose of this conference is to advance a discussion about how the law should face the threats that the modern world is facing today. How democracies can defend themselves against the non-actors, against the terror organizations who hide among civilians, who use them as human shields. How the armies in Western democratic states can fight and not being charged with war crimes. Thank you so much for joining us the second day of the Two Words of Law conference and be part of this vital discussion. Thank you.
It is my great honor to introduce to you Dr. Korir Singh Oy. Dr. Singh Oy currently serves as the legal advisor at the Executive Office of the Deputy President of Kenya. Previously, he served as the litigation director of Katiba Institute and also rule of law specialist at the U.S. Agency for International Development. Dr. Singh Oy was the founding director of the Center for Minority Rights Development, a Pan-African nonprofit organization. He was a Fulbright Scholar in 2007-2008 at the University of Minnesota School of Public Affairs. The scholarly writings of Dr. Singh Oy have been published in many international legal journals and edited volumes. Please welcome Dr. Singh Oy.
Shalom and good morning. I'm extremely delighted this morning to be given the opportunity to speak to us. And especially so for me this morning, having been present throughout conversations yesterday and having really understood what is going on, I really appreciate this conference. I feel the timing of it and the message of it could never have been more urgent. I want to, to also say that I make this presentation in the presence of the Kenyan ambassador here in Israel, His Excellency General Njoroge, who himself, like many of you in the room, is a highly decorated former military general, in the Republic of Kenya, and has served in this country as ambassador for a couple of years. And so I'm really privileged to be with you this morning, Your Excellency. Yesterday, I problematized the International Criminal Court based on our experience as Kenya. I argued that the 6 years that we've been before the International Criminal Court were enough to tell us what kind of court it is, how it operates, the huge gap between the normative framework and the propositions in the statute and the actual practical application of the law as set out in the Rome Statute. And I argued yesterday that as Kenya, we no longer hold any ambiguous position on the matter of the ICC. We're very clear that this is a court, the existence of which is incompatible with our national interest, and we will have nothing to do with it going forward. This morning, I sort of continue on the same theme, but really looking at it more broadly in terms of Africa. A lot of things happen in Africa. Emerging out of difficult post-colonial history, states in Africa grapple with difficult socio-economic challenges, as well as political challenges. And often you have heard the manner in which Africa has been characterized in the media, especially in the media, by the Western media. But it's enough to say that a lot of violence also takes place in Africa. But that's not to say that there's nothing good that's going on in Africa. I'm here to argue this morning regarding basically two things. One, what is Africa's case against the International Criminal Court? Beyond Kenya, what is Africa's case really? And then secondly, Africa is also seeking to provide solutions in terms of addressing atrocity crimes. There are about 5 reasons why today Africa's position is antagonistic to the International Criminal Court. And I think you had some of that in yesterday's conversation, especially from Ambassador Bolton. The first is based on the decade and a half of the ICC's existence, the choices of cases and situations before that court suggest that that court is a racist court. Africa's situations dominate the court's agenda, from Sudan to Central African Republic to Cote d'Ivoire, Mali, Libya, Kenya, and more recently Burundi. And that is why, based on this criticism, of course, you have recently had the court beginning to take an interest, for instance, in what goes on in Israel, because it's feeling this criticism of the fact that the perception out there and the story about the court out there is that it's a racist court. And so it seeks to pull out or to pull in, another country so as to create the impression that maybe it's not racist. And of course, that country most likely is Israel. So that's really our first objection against the ICC as a continent. And this has been captured in various resolutions, including resolutions of the heads of states assembly of the African Union that meets twice annually, in various capitals in Africa. The second objection that we have is the fact that the way cases are initiated at the ICC is problematic, especially we have in mind the referral mechanism. ICC can get seized of a matter or a case or a situation by way of referrals. These referrals can be self-referrals by the countries in which the atrocities take place or took place, or by the United Nations Security Council. Both referrals, from our perspective, are objectionable. In terms of self-referrals, if you observe the history of self-referrals, if you observe Cote d'Ivoire, if you observe Uganda, if you observe Democratic Republic of Congo, one of the things that strikes you is that the persons who have been referred before this court are literally political actors in the opposition. So that the most convenient way of eliminating your opposition or your opponent is that if there is an atrocity or there is a crime, you eliminate them by way of referring them to the International Criminal Court. Now, is that court then one that promotes democracy? If it is in fact providing incentives for the elimination of an opposition, our argument obviously is that it doesn't. But more importantly, referrals by the UN Security Council are extremely problematic. It's Africa's view that, of course, the Security Council itself, when you look at its membership, at least 3 of the members, of the real senior members, veto-wielding members of the UN Security Council, are not members of the ICC. None of them are members of the ICC. The United States are not members of the ICC. They're not state parties. China, Russia, they're not members of the ICC. They know better. And yet, they can and they have referred other countries, including countries which themselves are not states parties to the Rome Statute. What does that say about our treaty, the nature of our treaty law globally? What is the implication of that on our understanding of the Vienna Convention on Law of Treaties, which obviously provides that as a state, you can only be obliged to comply with a treaty of which you have ratified or which you have become a party to. And so there is a huge problem in relation to the manner in which referrals take place. Worse than referrals are the questions of deferral. Any matter that is initiated and referred to the court by the Security Council can also be deferred by way of the same UN Security Council. But the thresholds for deferral are not set out. They are very ambiguous and innocuous and arbitrary. And so there are no standards really that inform which cases can be referred and which cases can be, which case can be deferred and which ones cannot be deferred. It's whimsical. It's all based on power and the power of the Security Council. And that's why related to this, of course, has been Africa's pursuit of reform even within the UN Security Council itself. The third objection that we have is, and I think this is quite critical, is that Africa feels strongly that the ICC has a sequencing problem. Whenever a mass atrocity happens, and I spoke yesterday at length about the Kenyan situation, what should happen first? ICC says, forget about peace. What we want when there is an atrocity is immediate justice. But can you really achieve justice if in a situation where there's huge, there's no peace, there's no stability, the state has been undermined and weakened? Our argument is that you cannot do that. In fact, there is evidence that you undermine, you create greater vulnerability of people if you pursue justice in a situation, of instability. It has happened in Sudan, in Darfur. In fact, there is evidence to suggest that the indictment of President Bashir delayed the peace process in Darfur, and led to even more deaths and more displacement, and more destruction of property. Had that been realistically and pragmatically sequenced, in fact, we would have seen justice coming way after the stabilization process, has matured. The fourth objection that we have is around fair trial issues. And Israel and Kenya and other advanced democracies hold fair trial to be sacrosanct. And fair trial is about fair process, it's about due process. And one of the constituents of fair trial is that an accused person ought to be confronted with a charge, with a very clear, concrete charge at the very beginning of the trial, so that as an accused person, you can have the facility to prepare your defense. Unfortunately, in the ICC, when you're an accused person, you're dealing with a fluid charge, as it were, because that charge is bound to get recharacterized. Your culpability can get recharacterized at any time during the trial. So that if there is, if you are charged with murder, and peradventure there is no evidence really for murder, but they find that you're guilty or culpable of incitement, that charge can get recharacterized just before the judgment is issued. The stability of justice is clearly undermined, through this kind of process. And there's several other fair trial guarantees that are undermined in the ICC. Lastly, we argue, and yesterday Ambassador Bolton made this argument around the fact that there are no checks and balances, the lack of oversight, at the ICC. As you know, the Assembly of States Parties is supposed to be the one that provides oversight over the court. But when you look at the ASP, the Assembly of States Parties, you see a lot of power asymmetry. You see an assembly that is totally controlled by the European Union. You see an assembly that, where African states have very little or limited voice or agency, where even an agenda by the African Union, a proposition by the African Union struggles to find itself on the agenda of the Assembly of States Parties. Article 102, subarticle 4 of the Rome Statute provides that the Assembly of States Parties should set up an independent oversight mechanism to provide inspection, evaluation, and investigation of the court in order to enhance its efficiency. So this is actually, the independent oversight mechanism is supposed to be the body that ensures that in the conduct of, in its conduct, the prosecutor's office does the right thing. In its conduct, the judges of the court do the right thing. But 2.5 decades after its existence, this independent oversight mechanism that is mandated by the statute has not been operationalized. This is a court that is, it is very, very keen to prescribe accountability to others, but very, very unwilling to be subjected to any form of accountability. And so, what does Africa propose? Of course, in the long term, the prosecution of mass atrocities must happen, but it must happen within countries, within domestic judicial systems. Those systems need to be strengthened, their capacities need to be enhanced, and that is really where our partnership with Israel becomes extremely important. In a context such as Kenya, we have established a division of the High Court dealing with mass atrocities. And that division is working very closely with various countries in terms of ensuring that its capacity is enhanced. But in the midterm, Africa has come up with a mechanism, the African Court of Justice and Human Rights. Now, what is incredibly important to note about this court, which, whose protocol was adopted only 2 years ago in Malabo, and whose coming into effect is pending the ratification by 15 states, is the fact that when you look at the jurisdiction, the crimes within the jurisdiction of the African court, you would see a real attempt on the part of the African continent to address its challenges. For instance, apart from the ICC-type crimes, genocide, crimes against humanity, etc., under this court, it is a crime to undertake unconstitutional changes of government. Something that's quite common in some parts of Africa. Coup d'etats. Coup d'etats, perpetrators of coup d'etats, which cause violence and deaths and mayhem in the continent, will not escape and prosecuted because it is a crime under that court to undertake unconstitutional change of government. Piracy happened in the coast, in the coast of Somalia, in the coast of Yemen, among other places, in the West African coast. The crime of piracy is punishable by this court. The crime of terrorism, something that is completely outside the ambit of the ICC, is again a crime under the protocol to the African Court of Human and People's Rights. Corruption and money laundering, trafficking of persons and property, including hazardous wastes, illicit exploitation of natural resources, and mercenarism. All this are crimes within the jurisdiction of the African Court of Justice and Human Rights. Now, is Africa trying to run away from accountability? Clearly not. Africa is saying that, in fact, the ICC jurisdiction or the ICC crimes are important, but they don't really speak to the particularities of the challenges in Africa. And that there are some serious crimes that ought to be international crimes for purposes of Africa that the ICC doesn't even take cognizance of. And that's why it is our view that, that this court and this mechanism, should be supported. And so, ladies and gentlemen, I want to submit to us this morning that as Kenya and as Africa, we have very clear positions, and we are looking at learning and partnering with our friends and colleagues in Israel going forward. Thank you very much, and God bless you.